हेलो एवरीबॉडी, वेलकम टू द स्पीड स्क्रिप्ट एकेडमी। आज आपको डिक्टेशन मिलने वाला है एक लीगल मैटर का, ठीक है, जो कि इसमें टोटल 501 वर्ड्स हैं। तो आपको नियर अबाउट 70 वर्ड्स पर मिनट, जो कि स्पीड फ्लक्चुएट कर सकती है, उस पर डिक्टेशन मिलने वाला है। बाय द एंड ऑफ डिक्टेशन आप अपने टेस्ट को टेक इट एज अ टेस्ट। तो बाय द एंड ऑफ दिस डिक्टेशन आप अपने टेस्ट को जो है चेक करेंगे, ठीक है। और आपका यहाँ पे टारगेट होना चाहिए मिनिमम 90% एक्यूरेसी, ठीक है। सो गेट रेडी फॉर द डिक्टेशन। डिक्टेशन विल स्टार्ट इन 5 seconds. Start. The High Court of Delhi at New Delhi in writ petition number 398 of 2018, by which the High Court has allowed the said writ petition preferred by the respondent number 1, original writ petitioner, and has declared that the acquisition with respect to the land in question is deemed to have lapsed under section 24 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013, the Delhi Development Authority has preferred the present appeal, full stop. At the outset, it is required to be noted that wide notification issued under the provisions of Section 4 of the Land Acquisition Act, 1894, large tract of the land measuring about 200 bighas falling in village Vijayanagar was sought to be acquired, full stop. A declaration under section 6 of the act was issued and published, full stop. Thereafter, the aforesaid persons came to be mutated in the revenue records, full stop. Thus, the respondent number 1, original writ petitioner, can be said to be subsequent purchaser who acquired the right, title or interest in the land in question much after the land acquisition proceedings and the award was declared, full stop. The respondent number 1 herein, original writ petitioner, filed the writ petition before the High Court to declare that the acquisition with respect to the land in question is deemed to have lapsed under section 24 of the Act, 2013, on the ground that the compensation with respect to the land in question is not paid, full stop. Though it was specifically the case on behalf of the appellant before the High Court, so stated in the counter affidavit that the possession of the land in question was taken over on 15/12/2007 by drawing the Panchnama, and that original writ petitioner, being subsequent purchaser, had no locus to challenge the acquisition, by the impugned judgment and order, the High Court has entertained the writ petition preferred by respondent number 1, original writ petitioner, and has declared that the acquisition with respect to the land in question is deemed to have lapsed under section 24 of the Act, 2013 full stop. Under the circumstances, the High Court has seriously erred in entertaining the writ petition preferred by the respondent number 1, subsequent purchaser who had acquired the right, title or interest in the land in question subsequent to the acquisition proceedings, subsequent to passing of the award full stop. Under the circumstances, the impugned judgment and order passed by the High Court is unsustainable full stop. Even otherwise on merits also, and in light of the subsequent decision of the Constitution Bench of this court in the case of Indore Development Authority versus Manohar Lal and others reported in the impugned judgment and order passed by the High Court declaring the acquisition with respect to the land in question is deemed to have lapsed is unsustainable full stop. As observed herein above, it was the specific case on behalf of the appellant before the High Court and so stated in the counter before the High Court that the possession of the land in question was taken over full stop.